Yes, you have been asking me on the text message service, please, 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 can we hear from David Whiting, who, of course, is the man who knows everything about legal questions and is here to take your calls, 1300 222 774, and a big welcome to our Facebook viewers as well. David, good morning.
Good morning, Ali.
You were nearly usurped by the Premier there, but it's okay.
He's only done it once before. He normally manages to make his at 11, so that works well.
You'll need to send him a message and say, look, okay, next week, could you just do your press conference at 10:30?
Well, the problem with that, Ali, is that someone in my office happened to send him an email and the autoresponder said it's an 8-week response time.
Okay, all right, well, we won't worry about that. Now, yep. David, I'm just going to reiterate to people, please do call. We will run David a little bit after the news headlines as well, so don't panic. We're not going to squeeze him too much. David, you did have some homework, though. Remind us about Anna from Montrose.
Anna lost her daughter 25 years ago, a young daughter who was buried, and at that time she was married. That marriage has come to an end, and the ex-husband is now told one of the children that his spiteful approach will be that he will want to be buried with his daughter. So the question that Anna had was, how do I make sure that that doesn't happen? Well, the law says that if you have the right of burial, you are entitled to be included in the grave. And it's inevitable that, as Anna said, her ex-husband had arranged for the gravesite for the daughter. He will have the right of interment, and he's the person who's able to say, yes, you can be buried there. So it will really be a question of Anna's persuasive skills with her ex-husband's executors about making alternate arrangements for the interment of his remains. Now,
is there any mechanism, David, to have that right of internment removed if circumstances change?
No, it belongs to somebody. There are lots of instances where they don't get used, but the right of interment is held by the person who bought it.
Okay.
So, and the legislation, that's where the legislation sits at the moment. It's not something that you would ever think you would want to resolve in a family law matter, but, that's maybe something that people ought to do. Yeah. While I got most of that from the legislation, I got some great help from the cemeteries here in Victoria, and 2 bits of information. If you want to know why graves are so expensive, the answer is they have to budget for 100 years maintenance for each grave. And the second is I asked them, had their practices changed as a result of COVID, and to which their answer was no, because it's essentially an airborne disease and it doesn't make any difference to the way they process what they process.
That's interesting, actually, because we've seen in other countries, actually, recently, the reburial of some of the early victims of the coronavirus who were buried in a hurry because of concern about ongoing contamination. And then once they realised that there wasn't going to be a problem from people who had passed away, then they reburied them with the full honours.
Yep.
Well, David, thank you. Let's go straight to calls because time is, of course, of the essence. Lindy has joined us from Warncourt. Hi, Lindy.
Hi, Ali.
David's on the line. What did you want to ask him?
Oh, good morning, David. It's regarding I have a question regarding a land acquisition claim that we currently have with VicRoads or
yes.
Department of Transport. They've changed their names a couple of times.
Rural Roads Victoria, I think you'll find.
Okay, we get told by the acquisition law firm to refer to them as the authority. So I just thought that they were the authority. But anyway, it first started in 2012. We had our first notification from them. Signed up with an acquisition law firm in Melbourne. Been a lot of things that have happened, but in brief, I'm trying to sort of condense 8 years of struggles down. 2016, we have a small Angus breeding stud. We had 45 acres. We had 23 registered breeder cows. VicRoads were non-committal as to when the actual work on our property would commence. We gave them early access as an act of kindness so they could come and measure and do things. by 2016, we were getting concerned. The works were getting close, and there was no commitment about our property. We're on the corner of the Princes Highway and a side rural road.
Yes, you're on access road. Yep.
Yep. The land was acquired legally in 2017, but in 2016 we decided ourselves to start downsizing our herd because we knew we would have land constraint problems. In August 2017, Vic Roads removed our entire front fence of our property and a partial bit of our side fence as well, so that rendered us...
Lindy, a couple of comments. The first of all is that under the acquisition notice there will be a time at which they became entitled to the land. So, and I presume that would be well and truly before you took your fence, and it might have been... So you continued to use the land that they had in fact acquired from you?
No, we couldn't use... They took our entire front fence down, so we couldn't use the front of our property at all.
But by the time they took the front fence down, had they not already acquired the land inside your boundary that they were acquiring?
Yes, they acquired it just beforehand.
Yes, so in fact at the time they took the fence down, the fence was between, if one wants to be technical, land they owned and the highway.
Yes.
Yes. Okay.
Yep.
But there was no replacement fence put up between the land that you still owned and the land they occupied, yes? There are rules in relation to who contributes to fencing, but that would have been part of your compensation claim.
Well, the compensation claim very tricky. We've been compensated for the land. We've been given the money for the land. It's what do they call it? It's the solatium that we're...
It's the solatium and the injurious affection. It's the, what effect has this had on the business that I run? What effect has it had on the value of the balance of my land? Yes?
Yes. So from the time they took the front fence down, we started selling cows. By 2008...
Lindy, I'm sorry, I'm going to interrupt. Lindy, you really need to get to the crux of this, I think.
Lindy, I think the question is really, the question I don't know the answer to, is the question, at what point do they measure that affection? Now, I would have... Yep.
Yeah, I guess our problem is, with all the to's and fro's and the compensation thing going on, Vic Road said that temporary fencing was erected on our property and we didn't have to sell off our cows. This was not true. We know the fencing...
Then that's a question of fact that will be determined as part of the process, because they will be able to, if they've in fact put up the fencing, they'll be able to prove that it went up, and you're saying that they didn't.
It would seem a dispute on facts, wouldn't it, David?
It would appear to be. So, Lindy, keep going with the people that you're using, and it just land compensation is an aggravating issue.
Lindy, I'm going to leave you there. I'm sorry, but we don't have much time, and we do have a full board of calls. Michael in Kilsyth.
Yeah, g'day, David. Thank you for taking my call. I did a sleep apnea test where I had to take the machine home and I had to leave a deposit. But instead of a deposit, they just took my credit card details. So I've returned the machine and it's all fine. But I just wanted to know, I don't want them to have my credit card details anymore. Can I legally request that they remove it off their database or whatever?
If they're governed by the privacy principles, yes, and even if they weren't, you should be able to say, you held my credit card details for a specific purpose, you no longer need them, please confirm that you've destroyed them.
No worries.
Michael, thank you. And in fact, David, really, most organisations, because you often give your credit card details as a guarantee of something, and most organisations commit to, once you've returned whatever it is you were guaranteeing, to removing them, don't they?
The problem is slightly different. When we used to fill out a manual credit card payment and they would take an impression of your card, they wouldn't use it, they could give it to you or it could be torn up. But now it'll be maintained on a computer database somewhere.
Ah, okay.
So under Ali Moore's name is all of the credit cards that she's got because she's left them at various points in the past.
Let me tell you that it won't help them very much. That's okay. Graham in Northcote. Good morning, Graham.
Good morning, Ali.
Fire away, Graham.
This is to do with gift versus non-gift payments. My son's father bought a property which was an investment property, and he put my son, partner and children on that land to live. And I was my son told me that he'd been promised that eventually that land would go to him and his partner.
Yes.
Since then, that was in 2014, that relationship ended in April this year. Now, after that, I was asked by my son, by the father of the partner, this is getting complicated, my son...
Well, we'll call him the father-in-law. They may not be married, but father-in-law makes it easier, yes?
The father-in-law asked me if I could contribute to stamp duty on the property, which I did, which was $8,485, and that went to the solicitor's trust account. And
so where are we at? Where are you up to? So you contributed to the stamp duty. Is that so? What's the issue, as it were?
That relationship's broken up. I was under the very strong impression that that property would eventually end up in part in my son's hands.
Yes.
Am I entitled to reimbursement of that money?
Well, you contributed to stamp duty. Where did the stamp duty went to put the property in whose name?
Into the father-in-law and mother-in-law's name. I have no legal standing on it.
They went and purchased a property in their name, and they told you that they would be ultimately passing it on to their daughter and your son, and in return, would you mind kicking in some of the money for the stamp duty?
That's correct.
All I can say is wow.
And also, they then asked for me to help pay with the mortgage payments, which I did between October 14 and March this year, and that amounted to roughly $20,000.
Wow.
Then I would be having a discussion with them about, I gave this money on the, on your promise to do X and Y and Z. Are you still going to honour your promise?
Mm.
The difficulty, as I see it, though, is it might be 10 or 15 years before the property would be passed on.
Correct.
Yeah. I think you've got a problem, but I would be getting your son will be getting some advice as a result of the breakdown of the relationship. I would probably be addressing it there.
Graham, good luck with that. And we're with David Whiting. I'll take a couple more of your calls, given we were interrupted by the Premier and his usual press conference. Roger in Ivanhoe. Hi, Roger. Oh, Roger, are you there? No, I don't seem to have Roger. I'll try Russell. Russell, always bad when this happens. Russell in Bentley. Good morning, Russell.
Good morning, Ali. Hi, David. Thanks for taking my call. My partner and I and our two kids, we're renting a house, and I got an email last Friday from the real estate agent saying that the landlord's taking us to VCAT to try and get a decision to get us out within 60 days. The VCAT hearing is scheduled for next week, and we're sort of busily getting all our documents together. And we were under the impression that we would have a 3-month notice because we're on a month-to-month rent. So, and we've also talked to other people, and they've said that the real estate agent needs to give us 3 months' notice.
Russell, let's put that straight. Your line's a bit dodgy. Let's put it to David.
The normal requirement is that it depends upon the basis upon which the landlord is giving notice. My experience is that there is no, under these COVID rules, there is no automatic right to say, I want you out, you've got to go. There really needs to be a reason as to why you should go, and then VCAT would take that into account. So is it that if you having a discussion with them in relation to how much rent you should be paying, or is it just out of the blue you've got, I want to bring this to an end on 60 days?
It just came out of the blue. We applied for financial hardship back in April.
Okay. Rightio. So it's part of the wrap-up of that then. Right?
Well, they denied that, and we haven't heard anything from them for 5 months.
Right. Well, what then happens, there's two parts to this. The first part is that you can ask VCAT to determine what rent you ought to pay, because the process is you start with a discussion. If the discussion doesn't resolve, then what then happens is either the landlord or the agent, the landlord or the tenant goes to VCAT and says, I need you to tell me what rent is going to be reduced by. Now, on one might say, have you been paying, I presume you've been paying reduced rent since then, or maybe
No,
even
not at
no
all.
rent
No.
since then. You've been paying the full rent, have you?
We've been paying the full rent. They said, the landlord needs the money. So, but it's
Then
actually
then VCAT will take that into account in determining, first of all, whether the landlord is entitled to give the notice, and then if the landlord is entitled to give the notice, they then need to decide, is it appropriate for them to bring the tenancy to an end, and then what period there ought to be. So put all of your information together and you might choose to ask for a reduction in the rent over the last 5 months as part of the process. So it's a question of term and rent.
Good luck, Russell. Philip in Noble Park. Good morning, Philip.
Good morning, Ali and David. Thanks for taking the call. Good job, guys. Look, I phoned up in June regarding a VCAT phone hearing and let you guys know that how nervous I was, and Virginia asked me to call back to let her know how it went. So I'm doing that. The VCAT hearing went very well. It was a 5-way conversation and went very well. Everybody was heard, listened to, and was treated fairly, and quite a good outcome. But I do have a concern, David, after... And may I say that these guys work very, very hard. If anybody, VCAT and Consumer Affairs, as we know, they work together and they work so hard. And
Philip, what's your concern?
My concern is that after VCAT make orders, that there's nobody held responsible, that these orders are ignored. I've had 2 hearings with 2 orders. Both have been ignored by this.
Is that right, David? No right of enforcement?
The enforcement isn't done by VCAT.
Who's it done by?
Whatever the judgment or order you've got, you need to take it at least to the magistrate's court to enforce. So if there was an order that $1,000 be repaid or $10,000 be adjusted, then you need to go to the magistrate's court to get that enforced.
So you have to start another process, essentially.
Well, what you do is you register the judgment. You don't, or the order. You don't, and then becomes a magistrate's court order, and then you have the enforcement process. There's no rehearing. You simply go to the magistrate's court with a certificate from VCAT and you say,
Excuse me, David.
please read. Yeah.
Excuse me, guys. They let you know that the only other option is the Supreme Court, which is like, I'm an uneducated man, I'm self-taught, may as well say, and that's pretty much another language.
So have you tried the magistrate's court, Philip?
No, I was unaware of that procedure. David has just informed me of that, and I'm sure he's informed a lot of other people of that procedure because we're not informed of that process.
It's the enforcement process. Supreme Court proceedings are proceedings that you would take if you were... you can appeal or you can seek a review of the VCAT decision on the basis of a allegation that the law wasn't properly applied, not on the facts but on the law. So it will be, in my mind, magistrate's court to enforce the order.
Good luck. Gosh, anything to do with VCAT, I know it can be a challenge. Last call, Brett in North Melbourne. Hi, Brett.
Good morning, team. Thanks for taking my call. I've just got a quick question about, I lost my mother coming up to 2 years in November ago. An extended family member during the death, the sickness and death of my mum became executor and power of attorney. Now, in April this year, all the documentation and everything was ready and set for a final settlement. But then there was a tax return that needed to be completed on the final figure of the estate.
Yes.
So moving forward, July comes around, then COVID kicks in, and we are at a standstill with no word on what can be done, and all I'm getting, and I have no entitlement to be told anything because I'm not an executor. We're being told you just have to wait until after lockdown, and we'll let you know.
But you're
then.
a beneficiary, aren't you?
Yes.
So, Brett, I think the executor needs to be driving this. I'm doing estates at the moment, and we're still getting tax returns done, and we're still administering estates. I mean, life is still going on.
Yeah.
There may be a reason why...
The solicitor's reasoning is I can't get in contact with the accountant that is engaged to perform the tax return. And my answer to him is, well, if I engage a subcontractor to do work on my behalf, I'm in no position to tell my client, I can't tell you any information because I can't get onto my subcontractor. It just doesn't make sense.
Well, I would be incredibly surprised if there isn't a method of talking to the accountant who's doing the work. Incredibly surprised.
That's his continued line is I can't get onto him.
Well, then the executors may say to the executor, hire somebody else.
Yes, indeed. I mean, lockdown doesn't mean you can't pick up a phone or, hop online and
or write a letter and say, please ring me, but that's only going to take you a week.
Yes, exactly. Yeah. David, thank you. A little bit disjointed this morning, but lovely to talk to you. We'll talk to you next week.
Thank you.
David Whiting there.